Good morning, everybody. This is Tommy Johnson from the Portland Regional Chamber of Commerce. Thank you so much for joining us for today's virtual webinar. The title of this is How to Navigate Maine's New Earned Paid Leave Rules. We're very lucky to have two individuals from Verrill law firm with us today. The webinar will focus on Maine's new earned paid leave laws, which begin effective January 2021. As a business owner or operator, you're going to learn what actions you need to take now before the January deadline. A couple of housekeeping items. If you have questions for the presenters, there will be a Q&A at the end of the presentation. So right about the last 15 or 20 minutes, we'll do a Q&A. Please submit your questions in the YouTube chat box, and then they will be forwarded to our presenters to answer. You must be signed into the YouTube or Gmail or Google to participate. And just a reminder that a replay of this webinar will be made available after this presentation is done. Additionally, there will be an email that goes out that will include a link to the YouTube webinar replay, as well as the presentation deck that our presenters will be giving today. Now, about our presenters, Tawny Alvarez centers her practice on the understanding that the employment landscape is ever changing, and she recognizes that for companies to remain profitable and successful, they must be proactive, not reactive, to these employment issues. She's also the editor of the Verrill Labor and Employment blog, Taking Care of HR Business, and a co-host of the national podcast, HR Power Hour. She's a frequent speaker and author on labor and employment-related topics. Ben Ford is a partner in Verrill's Employment and Labor Group. He worked with clients to devise and implement policies to access, retain, and manage their most valuable asset, a well-functioning team of talented employees. Ben is also a frequent speaker and author on legal updates for employers. It's my privilege to welcome both Tawny and Ben.
Thanks, Tommy. It's great to be here. Hello, everybody out there. Hopefully you can, looks like you can hear me. I'm going to go ahead and share my screen now. We can get right into our PowerPoint. Okay, well, our journey begins. These are the topic today is some of the guidance that we've received from Maine's Department of Labor on Maine's new paid leave rules. When this law was passed last year, we got a lot of questions from people about what the law means, how it's to be implemented, what kinds of plans can we put in place, and of course, we couldn't answer any of those questions because we didn't really know any information about the law or how it was going to work or what kind of plans people can put in place. So then we just said, well, we'll have to wait to see how the rules come out. Don't worry, the rules will come out. Don't worry. And then COVID happened, and we're all focused on PPP and forgiveness and all of these other things. And we kind of let this one sort of escape from our consciousness for a little bit. And then a few weeks ago, some of these basic rules came out in the form of FAQs. So we thought this would be a really great opportunity to sort of put our minds into next year, start thinking about how this new law, how it's going to work, what are some things that you're going to need to do to refashion your business, or maybe you're fine, and how can we put a plan together for 2021 that complies with this new law. I do think it's pretty funny though that 2020 is the year that it is, and really in any other year these FAQs and these rules would be a really big deal because this is a new law for the state, and geeks like Tawny and I just absolutely love when new rules come out because there's great things that we can read into this, there's insights that we can have, and there's an opportunity to talk to people about how this is going to work and what are some things that we can do to take advantage of these new rules that might give our businesses an edge in the marketplace. Let's start with the basics. Let's start with what the actual statute says, the basics of the statute, and then we can get into the technicalities and the rules around those technicalities. The basics is the statute that was passed is that companies with more than 10 employees in Maine who are not covered by a collective bargaining agreement must give 1 hour for every 40 hours worked, up to 40 hours per year And the employees are not for regular employees, both full-time, part-time, per diem, but not seasonal employees. And we're going to get into what is a seasonal employee in a moment. So they get 40 hours per year. The 40-hour benefit begins accruing immediately, but it's not fully vested until they've worked 120 days. Not worked 120 days, but they've been employed for 120 days. So it's not consecutive days, it's just employed for 120 days. Really simple, right? Easy. Everybody gets that, no problem. We can just move on. I can go get another cup of coffee and we're good, right? Are there any questions?
Of course, we know it's never going to be that easy because this statute does not sit in isolation. We don't have the Maine paid leave statute kind of sitting out there all by its lonesome. We have to figure out a way in order to make this statute work in conjunction with all the other leave laws and statutes in which an organization may otherwise be covered by, both under federal law and under state law. So as we're talking about eligibility, obligations, notice requirements, all those things, you need to continue to reference and keep track of the fact that you still have obligations under Maine Family and Medical Leave Act if you have 15 or more employees, the Federal Family and Medical Leave Act if you have 50 or more employees, the ADA, the Maine Human Rights Act, domestic violence leave. All of these different leave statutes still continue to play a role, but now we're adding on these paid statutes. No matter what, every employer who has 10 or more employees, as defined by the statute, is going to have something that they are going to need to do kind of following this presentation. I do have good news, and I know that that is super surprising on a webinar like this. But the good news is that this doesn't take effect until January 1st. And guess what expires on December 31st? So the FFCRA is going to expire on December 31st currently, and unless we see action by Congress generally. So on December 31st, you can wipe away all the knowledge you have regarding the Families First Coronavirus Response Act and your obligations there. And in that space in which you're holding that information, you can now insert all the Maine paid leave information. So let's talk about eligibility. Individuals who are full-time, part-time, or per diem employees are eligible. The question I've been getting is, Tawny, what about if my handbook says that per diem and part-time employees aren't eligible for paid time off? They're not eligible for any benefits. They don't get health insurance. They don't get short-term disability, long-term disability. I don't have to give them this benefit, right? Unfortunately, that's not right. Your per diem employees will now be eligible. So while they may not be eligible for other benefits in which you provide statutorily, your part-time, your full-time, your per diem employees all are going to be entitled to receive this form of paid leave under the Maine statute. So we know that individuals are entitled to receive 1 hour of paid leave for every 40 hours worked. And the question then becomes, well, that's fine and dandy from an administrative standpoint if I am keeping track of the number of hours each person works. But for my salaried employees, I don't keep track of that. They might work 60 or 80 hours a week, but they get paid a salary. I pay them one lump sum, and I don't know how many hours they worked. Do I have to pay them based off of those 70 or 80 hours worked? Do I have to pay them that paid leave? And the answer is no. The Department of Labor's regulations came out and indicated that salaried employees are presumed to have worked 40 hours per week, so thus would be earning 1 hour of paid leave. So your salaried exempt employees, right? Because if they're just salaried non-exempt employees, you are still keeping track of how many hours they've worked, but your salary exempt employees, they're going to earn 1 hour a week. Now, the next question when we're talking about eligibility has been, okay, this only applies if we have 10 employees in Maine. What happens if I am a New Hampshire entity and I have 40 people working in New Hampshire, but I have 4 people working in Maine. Do those 4 Maine employees, are they eligible for paid leave under the Maine statute? So the answer is most likely no. So 10 employees in Maine means that you're looking at who you're paying unemployment for to the state of Maine. If you're paying unemployment to the state of Maine for at least 10 employees, then you likely are an employer under the statute and are going to have to provide the paid Maine leave to those individuals. Now, the big question, though, is, are you appropriately paying unemployment for the right individuals, right? So let's say, oh, well, I have 40 employees and some of them maybe sometimes work in Maine, but not all the time. This goes back to the question of, like, are you appropriately paying unemployment for the right individuals? That really, based off the Department of Labor regulations, is going to be the baseline analysis. The good news is that in 2000 I'm going to screw up on the year, but I think it was 2016, might have been 13 though. Oh, I shouldn't have used the year. We had the change in the independent contractor definition, right? So you don't have to pay this leave for your independent contractors. They're not eligible for it. You're per diem, you're part-time, full-time, but not independent contractors. So the next thing I've heard a bunch of from employers is, okay, well, half of my staff is independent contractors, so this really doesn't apply to me. Well, we don't have to pay for independent contractors. We don't have to pay the leave for independent contractors, but the question becomes is, do you appropriately have these individuals classified as independent contractors? So if you're scratching your head or wondering, I didn't realize there was a new rule, or maybe we're not appropriately classifying them, you're going to want to dig into that issue further and potentially consult with counsel on that issue. But generally, independent contractors are not going to be eligible for this paid leave if they're appropriately classified. And finally, employees of seasonal businesses who only work during the quote unquote season are not going to be eligible to receive the paid leave. Now, seasonal businesses are defined similar to other portions of the Maine labor statutes, but specifically you're looking at entities or organizations that are operational for 26 or fewer weeks during the course of a year. So that's what we're talking about when we talk about seasonal businesses, and individuals who are only seasonally employed are going to be exempted from the requirement to provide this paid leave. Ben,
one quick note before we leave this slide. I think just to reiterate what you were saying, Tawny, is that we use some shorthand language in here. Like, for example, we say if you're paying Maine unemployment, then that's considered an employee in Maine, but really it's dictated by the statute and it's dictated by the facts on the ground. So if you're not paying Maine unemployment for an employee, and you should, then that employee would also be eligible for this leave. Same thing with if you have somebody that you think is an independent contractor, but it turns out under the law they're not an independent contractor, then not only would you be liable for all the other stuff that you'd be liable for, but you'd also be liable for their paid leave under the statute. Okay, next slide.
So we talked about eligibility, but now let's talk about accrual. So can your 40 hours be front loaded? Some employers have said it's going to be an administrative nightmare for me to figure out how many hours a person's working and then how much time they're going to receive underneath the statute. Can I just give every single one of my employees 40 hours at the beginning of the year? The answer is yes. Look at that. Who knew that a lawyer could give a straight answer? But
it's never that simple.
The answer is yes, but if you're going to, at the end of employment, attempt to deduct any leave that had been taken and not previously earned, you're then going to have to still keep track of it, even though you front loaded. So as an example, My employer decides that they are going to front load all 40 hours on January 1st of 2021. And I, in the second week of January, decide to take all 40 hours. So by the end of January, I've taken all 40 hours of my paid leave. Then come March 1st, I decide to quit. I've got a better offer, I'm going somewhere else, right? The employer, if their policy provides, could seek to deduct any
Oh, we froze you, Tawny. I'm not sure if the problem's on my end or not, but
Ben, this is
notice,
Tommy.
however,
oh,
Oh.
okay. Is she back? Tommy? Do we have Tommy back?
I'm here. Am I not here?
Okay, I think you froze for a minute there.
Oh, okay. Apologies to everyone. Ben, can you pick up what sentence I was on when you lost me?
I think we were talking about if an employee if an employer decides to front load the time, and then an employee uses that time but then quits before they're eligible or before it's vested, what can an employer do in that situation?
Yeah, so if I quit in March after I've already taken all my paid leave for the year in January, the employer can deduct that amount, the unearned time that I've already used, from my final paycheck. And I know that our seasoned HR professionals are scratching their head and saying, but Tawny, there's limited ways in which I can take a deduction from that final paycheck. And the good news is that the Department of Labor has specifically noted that this is one of those situations in which a deduction can be taken. But if you are going to take the deduction, you need to have provided employees notice that if they have taken all the leave, but it's not all earned, that you're going to take this deduction. And you're also going to have to be tracking hours to know how much you can deduct from that final paycheck. So even though you front loaded it, if you plan on taking any deductions at the end of employment, you're still going to have to track the amount of time that's quote unquote been earned. Additionally, employees can roll over up to 40 hours per year. But the good news is that they're not just rolling 40 over and accruing more and more. So you don't find yourself in a position where an individual has accrued 200 hours of this paid leave. As long as you have a policy in place that sets forth the fact that 40 hours is the cap in which an individual can have of this paid leave, and individuals can roll over up to 40 hours per year, with the understanding that if an individual rolled over 40 hours, it's capped at 40 hours and they're not going to earn any additional time during the course of that year. The rule itself provides that an employee is entitled to take up to 40 hours a year, and it can be rolled over, but they don't have to earn more. So if I'm an employee and I roll over 32 hours, I have 32 hours in 2020 that I don't use, and I roll those over to 2022. During 2022, I'm only going to earn 8 hours of paid leave. Even if I use all 32 hours in the first week, I still am only going to earn an additional 8 hours during the course of 2022. So employer can cap that number. We also need to make sure that we're setting a policy as to how we're going to treat this time at termination of employment. So we can provide in our policies that we won't pay out, we won't treat it as wages at the time of termination, but we have to have a written policy that states that. If we're silent and don't indicate how we will treat this time at the termination of employment, the time is going to be treated the same way that your vacation policy time is treated. So if it says that vacation time will be paid out, then it's going to be paid out. If the employer chooses not to pay the time out based off of a policy at the termination of employment, and the employee returns to work with the employer, however much time that they had previously accrued they would be entitled to once they return to the employment of that same employer.
So that's if it's not paid out. And I think there's two really big points on this slide is you got to have the policies. So if you're going to decide that you're not going to pay out your time on termination, you got to have a policy that says so. If you don't have a policy, then you're really taking a big risk there, and you will have to pay it out upon termination. Same thing with front loading and then claiming it back of any unused or unvested time. You've got to have those policies in place. Those two policies are really critical, especially under this new law. Is this me? No, still you.
This is me, but you can jump in at any time.
Oh, no, I never jump in, Tawny.
So let's go over how we use it. So the time off is going to be paid out at the rate the employee was making the week prior to the leave. So in a lot of situations, this seems very straightforward. The employee makes $17 an hour. The employee will be paid out the leave at $17 an hour for any time they took. But if the employee receives non-discretionary bonus or commission or those types of payments, the individual, their regular rate of pay is going to be changed, and the employee is going to be entitled to paid leave at the rate of pay, which was their regular rate of pay in the week prior to taking the leave. So I know that's a big mouthful, but what you're going to do each time an employee takes the leave is you're going to look at their prior week, and you need to determine what their regular rate of pay was. And that's the rate of pay they're going to be entitled to for the leave that they take. Now, that means that over the course of the year, depending on when the leave is taken, you could be using different regular rates of pay, depending on when bonuses and commissions are paid out and when the time itself is taken. So administratively, you need to be very careful with this aspect of it. But Tawny, what happens if I have employees who we use the tip credit for? Do I have to figure out based off of their tips what the regular rate of pay was for each week? And what if they have multiple job duties and they're serving both as host or bartender, also as wait staff? The good news is that for those using the tip credit in the hospitality industry, you're using minimum wage. So minimum wage is what the regular rate of pay is going to be. You're not going to have to do the full analysis as to what the regular rate of pay was using tips earned in the previous week. So then the next question is how is it used? Do I have to permit people to take this leave in 6-minute increments if that's how I pay them? Can I put other restrictions on it? Can I require that people use it in a half-day increment? What happens if the type of work is such that I'm in the manufacturing industry and I can't have people who are away from the line for 1 hour, half an hour, just kind of at their own discretion? So you can have requirements that are set in place, but the maximum amount of time that you can require be used is 1 hour. So you can't say people have to take it in 4-hour increments. You have to limit it to 1-hour increments. Additionally, people are allowed to take this leave for any reason or no reason. My goldfish died. I need leave in a couple of weeks in order to grieve. My child is sick. I need time off. I want to hike Mount Katahdin. I want time off. All of those are perfectly reasonable explanations. And I just want to use my paid leave is also a completely reasonable explanation. Now you can have in place notice requirements, but those notice requirements cannot require that employees provide more than 4 weeks of notice for the taking of any form of leave. You can, however, have restrictions in place as to timing of when that leave is taken. And I think Ben's going to get into some more detail about those restrictions that we can put in place.
Yes, I will. But first, one question for you on that first point, Tawny. So let's say I have a business and I pay out commissions quarterly. And I pay out a commission on, let's see, March, at the end of March. And I have an employee that wants to take the first week of April off. It's in the next quarter. I've just paid them a $5,000 commission. How is that factored into that was the week prior to their taking the leave? Do I have to pay them an extra $5,000 the week that they take their leave?
You're going to have to look into what the regular rate of pay is during that period of time based off of receipt of that commission. It sounds like that commission was non-discretionary, that there was a commission plan in place for that period of time. And it wasn't some kind of holiday bonus based off of the goodness of the employer's heart that they gave this extra money. So yes, that amount is going to play a role in determining what the regular rate of pay was for that period of time. And accordingly, based off of the Department of Labor regulations, would factor into what the rate of pay is for the time off that happens that next week. So depending on the sophistication of your employees, there could be some interesting choices as to when this leave may be taken in order to optimize the amount of pay that is received underneath the statute, I guess is the best way to describe it.
Yeah.
Oh, keep going, Ben.
Wow, that was weird. So right, this is a planted question, but this is an area that Tawny and I were looking at, thinking, okay, sometimes when these new regulations come out, not every contingency in the world can be considered or thought of, and very often regulatory agencies have to go back and fix things or fine-tune things. This is probably an area that needs to be looked at, and how we're gonna calculate commissions into the regular rate of pay, because right now this is a potentially huge exposure to a company that pays out commissions on a regular basis.
Absolutely. And as we're getting close to the midpoint of the presentation, and Ben presented that really good question, I do invite people to add questions or comments into the question portion of your screen in YouTube, and we do have time for questions at the end. So I invite you to ask any questions you may have based off of the content that we presented at this time.
Yeah, so let's keep going. Next slide. So as we mentioned before, employees can use the leave for any reason or no reason. Maybe they want to catch up on some Netflix watching. Maybe they want to take a course in basket weaving. They can do whatever they want to do, but there is a requirement, or the employer has the right to set some minimum notice standards, and the notice standards turn on the reason for the leave. So while we've given you the ability to take the leave for no reason, we still need a reason, because we need to know if that reason is compliant with the notice requirements. Okay, so for example, an employer may require as much as 4 weeks, maximum 4 weeks notice for planned absences like vacations, or whatever things that you know that you're going to plan in advance. There's a new season of a TV show coming out. I really want to watch it as soon as it hits. I know it's going to come out third week of October. I'm taking that week off, and that's fine. But an employer can say, look, you knew this was happening well in advance, and I'm going to require in a situation like that you give us as much as 4 weeks. You can't require 6 weeks, you can't require 8 weeks, but you can require 4 weeks. And then for things like unplanned absences, the employer can put in a notice requirement that is feasible under the circumstances. I use the word feasible. I actually put that in quotes. That's not a quote. The FAQ says practicable, but practicable, no one knows what that word means. So I just put feasible under the circumstances. and for these unplanned absences, the amount of notice is going to change depending on what it is. If you have a dentist appointment, if you go to my dentist, they're booking out cleanings, 3 months in advance. So to say, oh, surprise, I've got a dental cleaning next week, that's probably not sufficient notice, especially when it's been on the books for a long time. If you chipped a tooth and you got to go to the dentist that day or a couple of days, yeah, that's an acceptable reason. But then there's other things that just come up: daycare closures, snow days, sometimes car trouble, and things like that. And in situations like that, then you have to give the notice as soon as you know that there's an issue. Tawny, what about like in a situation where an employee finds out that the daycare is going to be closed the next day? Does that mean that they have to send an email to their employer like that night as soon as they find out about it?
I think that it would be reasonable for the employee to provide notice as soon as possible. It may be that the employee is working on a contingency and is hoping to have someone else who's going to be able to provide care, but shooting an email to the employer and saying, I need to take leave tomorrow. If this changes, I'll let you know. But you can have policies in place that say, once you let us know, we're going to try to fill the space. So you need to let us know once you're sure. Those type of things is completely appropriate, but it's not 15 minutes before the shift starts, especially if you have, midday shifts or something along those lines. So asking employees, when did you receive knowledge that you were going to have this need for leave? It is appropriate. So that you can decide whether or not it was feasible for the employer to receive more notice at an earlier stage in the situation.
Yeah, that's right. And understanding when the employee received their own indication that they're going to need to leave becomes really important for the next slide. But so we'll table that for a moment. But this is a dialogue that really has to happen between the employer and the employee. It's probably not all that unusual for most companies, but if you're working in, say, like a retail company that's never had paid leave before, then you may end up with a lot more people asking for time off, and you're going to have to learn how to manage that process.
And then not just learn how to manage it, but if managers are often the ones who are going to receive notice, your frontline managers, there's going to be manager training that's going to be required so that they find out, the reason for either the delay in notice, whether or not the circumstances were such that additional notice should have been provided. And then when they bring it to HR's attention, you're going to have to question, is FMLA, is the ADA, are there other statutes that are implicated as a result of the verbalized need for the leave?
Yep, that's right. Last point on this slide is that an employer may include blackout periods for what they've called an undue hardship on the business. So back to our retail example, an employer can say nobody can take, no paid leave is available, for Black Friday. Or if you're in the height of summer, no paid leave is available for the week leading up to 4th of July. These are types of areas or times when they're absolutely business critical times, and an employer can include these blackout periods. Now, just we know how this is going to work. Somebody's going to try to push it a little bit and include these massive blackout periods. No time off for the entire month of July, or no time off for the entire month of December. So we don't know exactly where the line's going to be here, but it's going to be something reasonable. And we'll imagine that, as the years go on and we're living with this statute, that we're going to have a little bit more guidance as to what a reasonable blackout period or unreasonable undue hardship on the business might be, as defined by the Department of Labor through the various labor secretaries that come and go.
And we do have some hints. I mean, the Department of Labor use the language is undue hardship, which we know is included in other statutes. specifically with regards to the Americans with Disabilities Act, and that is a very high standard to meet. So keep that in mind when you're determining what an undue hardship is going to be.
Yeah, and an undue hardship might not be, well, I've got to overstaff or I've got to hire another person in order to fill the gaps. That might not be an undue hardship. But I think something like I need all hands on deck for the Friday after Thanksgiving. I think that might be something that would pass muster. So here's a couple of other things that sort of didn't fit into the categories that we pre-assigned. The employees they can't be disciplined for taking their paid time off. Of course, they have the right to that under the statute. But they can be disciplined if they exceed the amount of permitted leave. They can also be disciplined if they violate the notice requirements. So if you have a notice requirement that says I need you to give me as much leave as possible, or let's say you have a blackout period for the Friday after Thanksgiving, and somebody suddenly gets sick Thursday, and it doesn't look right to you, or it looks like maybe they might be gaming the system. That in some cases can be a disciplinary issue. I think you need to obviously look at all the circumstances, but if you get that type of gaming happening on a repeated basis, for example, you have to give 3 weeks notice if they're going to take a vacation day, and they get sick on the Friday before Memorial Day weekend, and they do that all the time, happen before Labor Day, happens before 4th of July, then that's a disciplinary issue. And you can go ahead and discipline them in a situation like that. The other thing is you need to update your posters. There's a new poster out that covers this, and so you can get those from the Department of Labor website. So gotta go get your new posters. And then we get a lot of questions about a doctor's note. Can we require a doctor's note upon their return if they say that they've been out sick? And it's complicated. Under this statute, no, unless they've been out for more than 3 days. An employer can require an explanation, just like we've been talking about. What kind of notice do you need to give? Why are they taking the leave? But you can't require like a doctor's note if they say that they're being sick. The employee doesn't have to justify the need for the leave based on or with a doctor's note unless they've been out for more than 3 days. But as Tawny is just about to explain, this conflicts with other areas of the law that would allow an employer to ask for a doctor's note. So Tawny, hit us up with that knowledge.
Yes, I mean, many of you likely right now have COVID policies and procedures in place in which if an individual is out of work because they have COVID-related symptoms, that they obtain or receive a doctor's note that clears them to return to work. If the pandemic is ongoing into 2021, which at this time, I mean, I think is likely, that arguably would conflict with an individual who takes, 1 day or 2 days off. They take Monday and Tuesday off because they're sneezing or they have a temperature. Under the paid leave statute, they should be permitted to return to work without a doctor's note, but that would be in violation of likely your COVID policies. In this situation, clarity to the employee saying our COVID policies require a doctor's note, as opposed to attempting to rely on the paid leave statute itself, is going to make the most amount of sense. It's not risk-free, and Ben and I are going to talk about some of the potential exposure, but the safety and health of your whole operations is potentially in jeopardy here. So making sure that your COVID policies are still being maintained. And then also under the FMLA, we know that if an individual is out of work for 3 days or more, whether consecutive or non-consecutive for the same illness or the same condition, let's say it's migraines and you're out once a month for this migraine, you might have knowledge that there's an FMLA qualifying condition and may choose to give the employee designation documents, certification documents, and that would be outside of the paid leave statute as well. But just being mindful that there are those other statutes or policies or practices in which we may be able to seek that information, just not specifically under this statute.
Right. Okay. So what if you already offer paid leave? You know, hey, I'm good. We're good, right? We offer paid leave, and you know, they accrue it and we pay them and it's all good. Are we in the clear here? And the answer is, well, you might be, but let's look into the details of your program. The rules that came out really say that in general, yeah, if you're offering paid leave, and as long as it's an equivalent benefit, then you should be okay. Well, what's an equivalent benefit? So what they'll say is, oh, let's look at your program. Can your employees, are they getting at least 40 hours per year, or accruing it at the rate of 1 hour for every 40 hours worked? Okay, yes, good, we're fine there. Can the employee use it for any reason? Well, what if a company only has a vacation policy, but they don't have any sick time? Well, then that's not for any reason. Or what if they only have sick time, but not vacation time? That's not for any reason either. So you would need to modify your program to conform with this state law. What if your vacation policy said you can use it for any reason as long as you give us 4 weeks or 5 weeks of notice? That's not good enough. So what you have to do is you have to look at your existing program and see if it meets the state standards under this statute, especially looking at use for any reason and feasible, or if you can pronounce it practicable for notice requirements, then and if it's accumulating at the same rate, the accepted rate under the statute, then you might be okay. But just automatically saying that we offer paid leave and then thinking that you're in compliance really isn't going to be enough in this situation. And then finally, enforcement. Tawny, tell us about enforcement. What are we looking at here?
So the statute's enforced by the Maine Department of Labor, so state statute, state enforcement. For each violation, where you're looking at a potential $1,000 fine. When I say each violation, I don't mean each person. It would appear that each time in which you fail to or refuse to provide the leave, or in which an individual experiences kind of adverse action as a result of taking the leave, those would all be individualized causes. I say causes of action, but the Department of Labor could seek violations for those. And then also, I mean, something to keep in mind is the fact that if you do have an employee who speaks up and says you're violating my rights, or I'm entitled to this leave, if you then retaliate against that individual, it brings us into the Whistleblower Retaliation Act. So while there's no private right of action that's specifically related to this leave, most likely we will see individualized or personal causes of action brought through the whistleblower statute.
Yeah, that's right. And I think if I was to look into the future, this is one area that I would imagine the claims, or a scenario that might happen. You got an employee, they're not happy, they're disgruntled, they're unhappy with their jobs or whatever, they feel that they've been unjustly treated. They say, I want to take my paid time off. The law says I get paid time off. The employer says, well, no, you actually don't get any paid time off. And and if you take that paid time off, you don't come back, or we're going to threaten your job, we're going to give you some sort of adverse employment action. The employee could then say, well, I was claiming my rights under Maine's paid leave statute, earned paid leave statute, and therefore I was complaining that the company was breaking the law by denying me my rights. Now, under the Whistleblower Protection Act, you don't have to be right. The employee doesn't have to be right. The employee doesn't have to be a legal scholar and know how the statute works in order to be correct. They just have to have a reasonable belief. And so I could see a lot of scenarios where employees claim to have to take this time off. Maybe they even go ahead and take the time off, and then they're terminated for doing so. And so that's something that we need to watch. But right now, exposure under the Department of Labor is, they're going to enforce it, but that exposure is not going to be as broad as it would be if there was a private cause of action here.
Additionally, something to be mindful of is if you as an employer believe the individual isn't entitled to paid leave and they take the leave anyways, and you choose not to pay, there could be a wage payment argument that's made kind of more generally, which would be a private right of action, as this time is considered wages underneath the statute itself. So you could get into something there as well. And that's going to be super fact specific, but something to just be mindful of as well.
That's right. And you get into those situations, you really want to call legal counsel. Wage claims are not to be trifled with. They are not. All right. So that's our prepared remarks, and there's our contact information. I'm hoping Tommy's going to jump in here with some awesome questions.
I sure am. And again, thanks again to both Tawny and Ben for a great presentation. A lot of important content. If you weren't able to ask a question today, you see Ben and Tawny's contact information right there on screen. That'll also be included in the post-event email that we'll send out tomorrow. Now we have a few questions from attendees. First is from Liz Tully. She is asking, let me get this up again. If an employee is hired to work the summer season and then we offer them a school year position, do we have to add on time from the summer season position after they accept a school year position?
Yes. So we're looking at 120 calendar days. So if they worked even just kind of part-time or a handful of days during the course of the summer, and then the thought was they were only going to be employed for 3 months, let's say 90 days. So you're like, well, they're never going to be at a place in which they can use the time. You still need to be keeping track of that time. The only time in which, there's a couple of exceptions that we didn't get into detail on, but if there's an employee who is an intern who's working through college credits, if that was the situation, there may be an exemption there. But more generally, if the individual has been employed for over 120 days, they're going to be entitled to use the leave, and the leave would have started accruing on their first day of employment.
Yeah, and also, I think the question might also be asking if they were classified as a seasonal employee and then became a non-seasonal employee. The way that the guidance is worded would suggest that even though they were a seasonal employee during season, as soon as they work outside of that season, then I think that accrual would still apply, and they would still be entitled to the earned paid leave.
Thank you both. The next question comes to us from Cheryl Patstone. It is this additional time earned over and above what we normally give employees?
So that depends. You can change your policies and practices in most cases, unless you have a collective bargaining agreement. I mean, if you have a collective bargaining agreement that is currently in place, then you wouldn't add on until you renegotiate that contract. And they very specifically provide that in the statute. If you just have an employee handbook or a policy and procedure manual that sets forth vacation time, sick time, earned benefit time, PTO, anything that you want to call it, you could incorporate this new requirement for paid leave into what you're already providing, but you'd have to segment it out most likely to make sure that you're very clear and that you meet the requirements under Maine's paid leave statute. So it may be that right now you offer all employees 2 weeks of PTO and they can use it for whatever they want. But you have to give 8 weeks of notice. Well, if that's the case, that PTO doesn't qualify under Maine paid leave statute, so you would have to divide it up. You can say you have 40 hours of PTO in which you have to give 8 weeks of notice, but you can use it for anything. And then there's 40 hours of leave that qualify under Maine's paid leave statute. So you don't have to give more leave, but you're definitely going to have to change your policies to provide the same leave with different requirements and notice standards.
Hey, Cheryl, good to hear from you. I think, yeah, Tawny nailed it. Basically, look at what you're already offering. If what you're already offering is giving 40 hours and is compliant with all of these other requirements, then it's not over and above what you're currently offering. But if you're currently offering a benefit that is not compliant with this or doesn't hit these median minimums, then it is over and above that requirement.
Excellent. Thank you, guys. Next question comes to us from Mindy Pelletier. Can the blackout period be by department, or does it have to be the company-wide?
It's a great question.
Yeah, I'd say by department makes a ton of sense because it's easier to make the undue burden argument. So the more you can specify different departments or needs or why exactly the blackout date is needed, I think the better. So the regulations aren't clear. They don't go into that much detail, but based off of other regulations and the way that the Department of Labor reviews these type of statutes, I'd say department by department is fine.
Yeah, totally agree. You know, when it comes down to it, if there's ever a violation or an investigation, you're going to sit across from an investigator or probably on the phone with an investigator, and you're going to have to justify what the undue hardship is. And if the investigator is saying, well, you know, does the blackout date apply to the whole company? Does your production staff really, they can't take the day after Thanksgiving off? And if the answer, if that doesn't make sense, then that's not going to make sense. So it's a great question.
We got a couple more questions for you guys. The next is from Diane Abramson. Can you require that earned paid leave be used concurrently with FMLA?
Tawny, you're taking that one.
Yeah. So that's a really good question. Interestingly enough, other than talking about how the statute interplays with your current policies, there isn't significant discussion regarding there's no discussion regarding FMLA, ADA, any of these other statutes. I would say that if you have a policy that provides that employees must use any paid time off prior to taking unpaid leave, that remains enforceable, which would mean that prior to taking unpaid FMLA, the employee would be required to use any accrued paid leave in this situation. The whole purpose of the act itself was to provide paid leave for people and not require them to take unpaid leave. So by requiring that all paid leave be used prior to taking unpaid leave, you're still working and operating within the, I think, policy expectations of why this statute was created.
Yep, I totally agree. I think you'd be on all fours if you required them to use this paid leave as part of their FMLA leave until we hear differently from the DOL, which I think is probably unlikely. I think, yeah, the regulations don't specifically set this forth, but at the same time, we know that if this was a private benefit that you were already offering and you had a policy saying that you have to do this, you have to use your paid leave, I think this is going to fall in that category.
And just a reminder from a historical perspective, I mean, this law went into effect at the same time in which the legislature was considering a form of paid family and medical leave similar to what's been instituted in Massachusetts. I think it would have been likely that we would have seen an act such as that in the next legislative session. Considering COVID, I think it's less likely that makes headway, but maybe. So it could be that in the next few legislative sessions that we get more answers to that based off of potential Paid Family Medical Leave Act statutes.
Excellent. And this leaves us time for our last question. It again comes from Cheryl Petstone. Are we still able to continue with the introductory periods for our new hires without earning time until they have completed the 90 days? Or does the clock start on day one for earned leave?
Clock starts on day one, Cheryl. They can accrue it. So they accrue the paid time off, the right to take the paid time off, but they can't use it until they have worked for 120 days, or they've been employed for 120 days. Not worked, but been employed for 120 days. So if you have a 90-day period, then obviously they couldn't take any time off within that 90-day period. But the accrual begins on day one.
People will be surprised, but I don't have anything to add to his answer.
Ah, unbelievable. No subtleties, no comparison to another obscure statute, nothing like that, Tawny?
No.
Oh, okay.
Well, thanks again, Tawny and Ben. And again, thank you to the 70+ people who participated. And be sure to visit the Chamber website, portlandregion.com, to check on any other upcoming events and to register for our weekly events newsletter. Thank you again and have a great day, everyone.
Thank you so much. Stay healthy, everyone.
Thank you, everybody. Thanks, Tommy. Thanks, Andrea.